Okay, we're back. We've just been talking about advancements and satisfaction, and now we're going to turn our attention back to what happens in a divorce when there's a will. So I want to talk a little bit about Friedman versus Hannan on page 236. James Hannan and Anna Covert were married for 20 years, and they did not have children. However, Anna had a lot of sisters. And James had at least one brother, and I'm not sure who all of the other guys were. Anyway, they divorced in 2001, and like many people, James did not get around to revising his will. Now, we know that we have a statute that revokes any provisions in favor of the now ex-spouse. James's will left property to Anna's sisters as well, however. So the clause in question in his will says it should be divided equally between my surviving immediate family members and those surviving immediate family members of my wife. And then there is a long list. Here it is. There's a list of names. Here it is, just split in half. And notice how this is kind of two lists. Here's this group with an and here, so you know how you put an and before the last one, and then this group, and here's another and before Kellyanne Friedman. So the question is, was this a gift to a group of people because they're related to the wife, or was this a gift to some individuals who happen to be related to the wife? Does that make sense, that distinction? Right? If it's a gift to a group, we're going to think about it a little bit differently, and we'll be looking at groups differently when we get to future estates too. So think about that. The question is, we're looking for group mindiness according to the court. Do you think perhaps this judge was a Stephen Colbert fan? Don't know. Anyway, we're looking for group mindiness. So are you convinced that the will refers to two groups rather than to two individuals? Kind of looks like it. Look at this. He mentions immediate family members of my wife before he lists these people, and immediate family members of his before he lists those people. If it is a group and it relates to now ex-wife, then does the statute revoke it? What do you think? Did this case come out right? The court says, yes, it did. We think this was just a group, and he's just referring to his wife's relatives, not to these individuals. Now, if you had a friend or a client whose divorce was just final, what advice would you give? Right? What are the various things that you would tell them they need to take care of and make sure they change? And what things would you want to tell them or have been changed? So if you want to leave it the way it was, you've got to do something. Here's the Uniform Probate Code. Dissolution or annulment of a marriage revokes any revocable disposition, beneficiary designation, appointment of property made by an individual to the individual's former spouse in a governing instrument. So would that apply to life insurance? Yeah, sure, right? That's a revocable beneficiary designation. What about joint tenancy? Yeah, it might apply to joint tenancy. I kind of want to look for another rule for joint tenancy because I think it's a little different. But it might. If I had transferred the property into joint tenancy, that might be an appointment of property to the spouse. So anyway, this is also the Minnesota version. And this rule that revokes everything automatically is based on the belief that most divorces are really acrimonious, pretty nasty, and that families also take sides. And so this is the question for the discussion board. Do you agree with such a broad application of this rule? Do you think it's the right rule? That, first of all, we revoke will provisions and every other kind of provisions. And second of all, we revoke provisions for the spouse, but also for all of the spouse's relatives. So do you agree that that's what most people would want? Because this is just a default. We can always jump through some hoops to make things come out differently. Go ahead and post on discussion board. All right, so where have we been in these two parts? First of all, we looked at advancement and satisfaction. Right? We can satisfy a will provision by making an early payment, or somebody might want to make an advancement of an inheritance. And the UPC we saw requires a writing to show that a gift was an advancement. And if there was an advancement, then we know how to use the hodgepodge to figure out whether the person who received the advancement gets anything else. In the context of divorce, we saw that if a testator divorces after making a will, the law automatically revokes it. Or not the whole will, just the gifts in it that go to the spouse. The Uniform Probate Code also revokes non-will beneficiary designations. And then we saw that groups are treated differently from individuals, and that's something to just kind of put on the back burner because we will have occasion to visit groups and individuals again. Okay, thank you for watching. Here are some cute pandas for no good reason except that they're cute, and I will see you in class. Thanks.